can pronounce the last name.
Yes, Your Honor, that was correct.
But I'm curious about the first.
Yes.
Could you pronounce it?
It's Btzalel, Your Honor.
Okay, thank you. Anytime you're ready.
Good afternoon, Your Honors. My name is Btzalel Hirschhorn, and I am representing the appellants in this matter, Avion Funding. May it please the court. This matter is before this court on direct certification from a bankruptcy court decision which dismissed the appellant's adversary proceeding brought under 11 U.S.C. 523A. Consequently, the sole issue before this court is whether corporate debtors proceeding under subchapter 5 of the Bankruptcy Code can receive a discharge of debts of a kind specified in 523.
You know, I noticed this issue was the subject of the National Moot Court competition.
Is it right? Yes, Your Honor, it was.
I didn't read anything in it, but it's a tough issue, isn't it?
It is, Your Honor, yes. When the bankruptcy court declined to follow the Fourth Circuit's ruling in Cantwell-Cleary, which to date is the only other circuit-level court to decide this issue, the bankruptcy court essentially legislated into 1192 what the statute does not on its face state. 1192 makes no distinction between a corporate debtor and an individual debtor. Further, the court in Cantwell-Cleary stated specifically that the use of the words of a kind in 523A is referring to the category of debt and not the category of debtor. Additionally, the bankruptcy court declined to follow the rules of statutory construction as set forth in Cantwell-Cleary. We believe that was also an error.
Should it concern us? I think, correct me if I'm wrong, every bankruptcy judge that has looked at this has disagreed with the Fourth Circuit, including the bankruptcy appeal, right, in the Ninth Circuit that's pending?
Yes, Your Honor. I would like to draw the court's attention to there were two cases also out of Texas that did agree with our position.
Oh, they did, bankruptcy judge.
Two bankruptcy courts.
I thought the Fourth Circuit cited the, what was that called, JRB Consolidated?
The Fourth Circuit did, Your Honor. The lower court coming out of Maryland, the bankruptcy court there, declined to follow our position and sided with the bankruptcy court in our case. The Fourth Circuit reversed.
I see, okay, I was wrong. So it's just a big question of statutory interpretation, and am I oversimplifying it to say it's sort of a debt versus debtor type distinction? Is that what?
I think that is correct, Your Honor.
Okay.
And the statutory interpretation tells us to follow the specific over the general. The specific statute dealing with 1192 the specific statute dealing with the subchapter 5 debtor is 1192. On its face, there's no distinction made on the statute between a corporation and an individual. The general statute, which is 523, incorporates a number of different chapters of the Bankruptcy Code. And because there is a tension between these two statutes that cannot be reconciled, we have to revert to the statutory interpretation of specific over general. Additionally, the Fourth Circuit cited to In Re JRB Consolidated, which was a 1995 case also out of Texas, which dealt with the context of Chapter 12. We're dealing with family farmers and fishermen. That statute, 1228, is very similar in construction to 1192. Both statutes state the term debts of a kind. In Re JRB Consolidated, the bankruptcy court there, which is still good law, held that corporate debtors proceeding under Chapter 12 cannot receive a discharge of 523 debts. There's another similarity between Chapter 12 and Subchapter 5, and that is the elimination of the absolute priority rule. To date, Chapter 12 and Subchapter 5 are the only bankruptcy chapters that have eliminated the absolute priority rule. And there's another similarity as well between Chapter 12 and Subchapter 5, and that is the debt limits. There's a debt limit of, I believe it's $11 million for a family farmer and $2 million for a fisherman. And if either the farmer or the fisherman is above those debt limits, then they would have to file for traditional Chapter 11. The bankruptcy court simply declined to follow In Re JRB because it said, in its view, Chapter 12 applies only to a small specific subset of debtors. And the bankruptcy court said, well, in the overall context of Chapter 11, it applies to many kind of debtors. But we're dealing with a specific subset of Chapter 11, and that's Subchapter 5, which has debt limits, eliminates the absolute priority rule, and the way it's structured is very similar to 1192.
The NABT amicus brief, its primary point is courts shouldn't be rebalancing what Congress did, especially not knocking out surplusage. And then they go on to say, Congress very specifically decided these small businesses need to keep operating rather than getting sort of torn down by 523 claims.
Yes. Well, in terms of that, Your Honor, the opposite argument can also be made that a creditor may be reluctant to even do business at all with the debtor prior to bankruptcy because of the concern of not being protected. And Congress also did not seem to have that concern with an individual. An individual can also be made subject to 523, and Congress didn't seem concerned that that should be a preclusion to apply 523 to an individual. So there's no reason that distinction should then be made for a corporation. If the court has any other further questions.
I guess are there anything instructive from the leading treatises, Norton, on this specific issue that you know of?
What I'm aware is that there's a general treatise discussion of the overall purpose of Subchapter 5, but I've personally not seen anything with respect to the intent behind the drafting of 1192 and whether that 1192 should apply only to a corporation or to an individual.
When was the Subchapter 5 done by Congress?
It was 2019 when it was passed.
Thank you. You've reserved rebuttal time. We'll hear from the government.
Thank you, Your Honor.
It please the court, Robert Branman of the United States, in support of reversal. My colleague, Mr. Hirschhorn, Mr. Hirschhorn did a good job presenting this case. He just reversed one little thing. The debt limits of for the family farmers are 11 million and the fishermen are 2 million. Yeah. But the point is that Chapter 12 and Subchapter 5 have a great deal of similarity. They're both for businesses. They both are for small businesses. They both cover individuals and partnerships and corporations. And were both designed for the same purpose.
How many different circuits are you aware of that this issue is being litigated in where you've taken an amicus position?
3. I filed a brief in the 11th Circuit.
You filed in the 11th, and you're participating in the 9th?
The 9th Circuit, we were considering it, but that case has been dismissed.
Oh.
The creditor dismissed her appeal. I think she took a settlement from the debtor.
Ah, okay. So the only other court that's considering this right now is the 11th?
Yes.
Okay.
And
Do you know where it is in the 11th? Do you know where it is in the 11th right now? Has it been argued or?
it has not been set for argument. I filed that brief a little bit after this brief.
Okay.
But the creditor in that case supplied the court with 2 unpublished bankruptcy court decisions that favored our position.
Yeah, I missed that. Thank you.
Yeah, I missed it too until I saw them there, and then my office asked Westlaw to publish them, and they did, and I sent them in as a 28J letter to you.
Thank you.
Okay. One other thing I wanted to respond to in the appellee's briefs about how to interpret statute bankruptcy exceptions. I want to say that they're not narrowly interpreted. The Supreme Court a long time ago and several times since has said that bankruptcy discharges are they mean only what is plainly expressed. And some courts have taken that to mean they are narrowly construed.
Against creditors.
Against
That's
creditors.
sort of a myth out there.
Well, the Supreme Court, of course, as we all know, has been on the mission of interpreting statutes according to their plain language. And that project got to bankruptcy discharges just last term in a case called Barton Werfer versus Buckley. It looked at, I'll give you the site, it's 598 U.S. at 69. It's unanimous opinion. The court looked at one of the bankruptcy discharges and looked at these earlier cases and said, we've never taken plainly expressed, we've never used that principle to artificially narrow ordinary meaning. in all those earlier cases, we reached the result using the text and ordinary tools of interpretation. And that's what they did in that case too. So that's the new regime for interpreting bankruptcy discharges.
In your brief, you used the phrase conforming amendment.
Yes.
Could you give me a little clarity? What is that suggesting? A preamble, if it's a conforming amendment, can't really have meaningful impact on what follows, or?
It's not the whole preamble is a conforming amendment. In the 2019 Act, there are 8 or 10 operative sections that do the real meat of the statute, including 1192-2, and that's what I would say is the important section for where to find our meaning. In Section 4 of the Act, there are some 30 conforming amendments that go all over the code to add a phrase here and a phrase there, or renumber things, and that's where they added the new number 1192 to the lead-in language to 523A. And so that's why I say that was a conforming amendment. I don't exactly have the authority that say conforming amendments are no good, but I'd like to say that if 1192 is plain, we shouldn't expect a conforming amendment to completely flip it around to say the opposite. And that's what I think the majority of bankruptcy courts that have looked at this and the Ninth Circuit BAP have done. They've focused on that addition of the number to the lead-in language, called it surplusage, and made their decision wholly based on largely based on the surplusage canon, which is just not that useful in this situation.
And it's not useful because you're saying the use of the term debt in 1192 cross-references the list. It doesn't really embrace the preamble?
Yeah, I'd say that just like a natural reading of the phrase kinds of debt in 523, you want to look at 523 and see what kinds of debts are here, and you see a long list.
Big thrust of the counter-argument is that Congress spent a lot of time thinking of how, for small businesses in particular, we need to keep them operating, generating income, keeping jobs. And therefore, even if there's sympathy on facts like these facts, we really don't want to slow them down in their recourse to Chapter 5, right?
I'd say that Congress wanted small businesses to be, if they should reorganize, then they should be able to reorganize, and they shouldn't be hemmed up by the administrative difficulties. But that's not just to keep businesses going; it's for the entire community in which they're enmeshed: their customers, their employees, their suppliers, their lenders. One way to look at,
but that would be a distinction from the farmers and the fishermen. Arguably, no.
I think they do the same thing too. I mean, I don't think Congress tried to make reorganizations better to favor debtors at the expense of all their customers and their community. I think Congress tried to make those things work with less, just make them work more easily for the entire communities in which they were enmeshed. I mean, one way to think about favoring small businesses is if this decision stands, businesses like the funding companies, the merchant cash advance, they will be less likely to extend credit to small businesses because they will see that through a small amount of fraud, they can lose their entire credit.
And that's sort of the wage theft amicus brief too. Same point, right?
Yes. Yeah.
Okay. Thank you, Counsel.
That's all I got. Thank you.
Mr. Lane? You have 15 minutes.
Thank you. Good afternoon, Your Honors. May it please the Court, my name is Chip Lane, and I represent GFS Industries, who is the underlying debtor in this case and is now the appellee in this matter. As Judge Higginson pointed out, this issue has been a very important one, and so much so that it was the moot court question this year. And one of the things that we were all taught as law students and practicing attorneys, and presumably as judges, and even the drafters of these statutes, is that words matter. Words matter very, very much. And the words that are at issue in this bankruptcy code, in our opinion, could not be more clear. The operative statute and bankruptcy code section today is 523. The action brought by Avion Funding was 523. And 523 has been clear and unequivocal since it was drafted originally, and then since it was modified after the SBR, the subchapter 5 was created in August of 2019. The discharge does not apply to corporations, and it only applies to individuals. And from all of our days back in law school till now, we were taught that you look at the plain language of the statute and start your analysis there. And the bankruptcy code at issue 523 in its preamble says that it does not discharge an individual debtor from any debt. It could not be more clear that it only applies to that. And more so when Congress took the time to create the new subchapter 5 that we're all arguing for today. Presumably they knew this section existed. They knew it existed only as to individuals, and it's not as though it was not modified. It was in fact modified. And the point
What's wrong with the Judge Niemeyer's and the government's and the argument that when you connect the dots, the reference in 1192 is to the debt. And so the 523 list is of the debts. We're not really asking about who the debtor is.
And Chief Judge Gargata, in his opinion, did spend some time on that issue. And it is, again, where I go back to words do matter, it's not of a debt. The statute in 1192 says of the kind specified in 523. And so there is a little bit of a limitation on that. The word a versus the indicates an intent to focus specifically on the debt specified in 523.
So let me see if I understand that. You're saying it would be different if it said of a kind specified in 523A as opposed to of the kind.
I don't think, I don't want to get too far off track there because I don't know how operative that a versus the is.
Well, so some Supreme Court cases turn on A's versus the's.
And they do, and that's why I brought that up. And I think Judge Gargata, in his opinion, did spend some time delineating that this is of the kind specified in 523. And there in the Fourth Circuit, they got in the Cleary case did get a little off track, if you will, on trying to analyze how 523 and 1192 can harmonize together. Can the two of those harmonize together? And it's our position that they absolutely can. In fact, the language of 1192, when the creation of the Subchapter 5 Act was created, was specifically put into 523, into the preamble there. And it was added, and if you look at the legislative history too, it says put 1192 right in between 1141 and 1228, indicating again Congress's intent not to modify 523 to expand it to corporations. In fact, I think it's the opposite. And I think that all of to Judge Higginson's point, all of the bankruptcy courts analyzing this have very clearly come to the conclusion that 523 was not modified to expand the scope of discharge beyond those of an individual to the corporations. In fact, 1192, those limitations to the types of debt in 523 are limited to the types of debts of individuals, not of corporations.
What's the, I mean, if there is a congressional history, what's the logic that sort of fake people, companies?
I'm sorry, say that again, Your Honor.
Why would fishermen and farmers still be saddled with the 523 companies, and yet we're going to say companies, which I think is fake people, aren't? What's the reasoning?
It's unclear, and I guess that's where there's some statutory interpretation that comes into why it applies to some and it applies to other. In a traditional Chapter 11, prior to the creation of Subchapter 5, corporations were never subject to 523 actions. That existed beforehand. The Chapter 12 cases and then the one that's been discussed, the JRB Consolidated.
But are they right that Congress used identical language from Chapter 12?
It's hard for me to say that it's identical language because there may be some question, and that's why I just can't remember it off the top of my head, whether there's some of that A versus the language. So I can't say that it is certainly similar. And if I can go back and let's talk about the JRB Consolidated case, because that's been cited. It was relied on a bit by the Cleary Court, and it's been certainly relied on in this case here. The one thing that has been omitted from the discussion is that case specifically in page 374 said that the holding in this case should not be extended to the Chapter 11 context. So very specifically, it said this is a Chapter 12 case, and it should not be extended to the Chapter 11 context. That's the main issue there. The secondary issue is obviously that case came around before Subchapter 5 was ever even contemplated coming into existence. So again, it's a little bit of apples and oranges by saying, yes, it's similar language, but we should apply it into the Subchapter 5 context when that case came out before the Subchapter 5 context even existed. So, but more so, the fact that court made it very clear it should not be extended to a traditional Chapter 11, which now, since its adoption in 523 for Subchapter 5, one would say if it wasn't applicable to a Chapter 11 context, it should similarly not be applicable to a Subchapter 5, Chapter 11 context. The second issue is, I apologize, Judge Duncan, your question on how far along is the 11th Circuit and where are they on this issue? It is my understanding that the appellee briefs are due as early as next week. Okay. Subject to an extension. So we are ahead of them. This court should make its decision before that court will even have oral argument, to the extent they have oral argument. And then Judge Higginson, you asked about the leading treatises. What's the leading treatises perspective on this? And I think that Judge Bonnefell's guide to the Subchapter 5 is sort of viewed as the leading treatise on this issue. He's out of a bankruptcy judge out of Georgia. And in his guide to the SBRA, he sums up these issues very clearly. And his treatise has been followed by not only Judge Gargata in this underlying case, but by a host of the other judges throughout the country. And it's trying to recognize that delineation between 1192 and the 523. And he states in his treatise that were 1192 established, which was created in the Subchapter 5, it didn't exist, were it to have existed by itself without adding the 1192 section over to 523, then potentially the United States government, the appellants, and everybody else might have an argument that you focus on the debt and not the type of debtor. But because 1192 was specifically added and inserted into 523, that's where that focus should go. And so Judge Bonnefell's treatise spends a good bit of time talking about that.
Counsel, Mr. Lane, if you could respond to one thing from Judge Niemeyer's Fourth Circuit opinion. He says that 523, the preamble or the introductory language, refers not only to 1192 but also to 1141.
It does.
And he says that the interpretation that you are advocating here would create difficulty in reconciling 523A with 1141D6. What is your response to that?
My response is there's actually no difficulty in reconciling those together. You do focus on, and the canon of focusing on specific versus general comes into play, not only with 1141D6 and 523, but also with 1192. All of those are at issue. And as it relates to 1141D6, that is a very specific provision exempting taxes and some other things that are not going to be dischargeable one way or another. Those debts would follow the owner. Those debts would follow a myriad of other things. But it is a very specific provision in there. The Section 523...
It would apply, his point is it would apply 523A to corporate debtors, notwithstanding the language individual in the run-up in the introductory language.
If I understand your question correctly, yes, Your Honor.
Okay.
The introductory language cannot be ignored, and 523 is I haven't counted the words, but my belief it is the longest and most detailed section in the bankruptcy code. And so it is almost inconceivable to come up with a theory that 523 would not be more specific than 1192. It is thousands of words of the very specific types of debts and allegations and whatnot that would not be dischargeable, whereas 1192 is a much smaller provision in there, and again it talks about the discharge provisions. But from our standpoint, and I believe that standpoint of most of the bankruptcy judges analyzing this, 523 is the more specific statute. over 1192.
What about the definition of, I guess it's the definition of debtor in subchapter 5 includes it is of a person, and person includes both corporate and individual entities. Why shouldn't we follow that as opposed to the signal in 523A?
And I think that goes to Judge Bonnefell's treaty, Judge Gargata's opinion here, and the other bankruptcy courts, is that had 1192 existed on its own, I think, Judge Duncan, I think your position would have a lot of weight in that you can focus on the word debtor or the type of debts, and debtor can be both. What defeats appellant's argument here is that the inclusion of 1192 into 523 brought it back into it's only applicable to individuals. So if 1192 existed on its own, there's absolutely a very good argument to make to that. But the fact that 1192 was included into 523 is from our standpoint, is dispositive of that issue.
Okay.
And, go ahead.
No, but that's okay, Your Honor.
The larger sort of policy set of arguments that have been made and exist in this issue about, conduct therefore being known and just the fraud being deliberate. You'd say there'd be ways to reach it that already exist in the bankruptcy code?
Absolutely. If there's a crime that's committed, the crime is not, so if it's truly a crime of fraud and there may be criminal restitution, that's never dischargeable. And so if an individual debtor commits a crime or a corporation commits a crime, then those debts are not dischargeable. The allegations against the debtor's principals here would survive, though they could pursue the individual. It would only apply as to the corporation. And I think Congress had the opportunity to weigh and balance that and realize that the potentially small number of fraudulent cases that could get discharged or otherwise in 523 are insignificant compared to the vast amount of small businesses that needed a cost-efficient and time-efficient way of reorganizing their debts. We're talking a very small number that currently have 523 actions in them. If this court reverses the opinion, the very opposite would be true. Well-funded creditors have the ability to bring 523 actions in all of these cases, and typically struggling small businesses that are taking advantage of the subchapter 5 would then be faced with more costly litigation and then would have to elect to not pursue subchapter 5 and instead try to allow a corporation to get its discharge by going into a very time-consuming, very costly Chapter 11.
But there are tools on the other side. A bankruptcy judge could declare some of these claims to be frivolous if they don't have any weight.
Absolutely. Or if something truly nefarious is happening and it's happening during the bankruptcy, motions can be brought. The subchapter 5 trustees in these cases can assume control of the company upon motion practice. There are absolutely avenues and tools in the toolbox that both creditors, the judges, and the trustees all have at their disposal in the event of something truly nefarious is happening here. Your Honor, I think, and I'll end, I've only got a minute left, again, with saying that words matter. The words of 523, again, could not be more clear. Individual means individual. There's no provision in the bankruptcy code where an individual is defined as anything other than just that, a human being individual. So it's our belief, Your Honor, that Chief Judge Gargata's opinion should be upheld in this court. Thank you very much.
Thank you.
Oh, sorry, yeah. Mr. Cook. And I always ask about scholarship. You wrote some scholarship that your brief cites. Do you agree with yourself?
They say fool for a client, right? Good afternoon, judges. My name is Richard Cook. May it please the court. I represent NABT, the National Association of Bankruptcy Trustees. This is the largest organization of Subchapter 5 trustees in the nation. I myself am also a Subchapter 5 trustee. I think a lot of the difficulties courts have grappled with getting to the answer to this question presented, we've kind of missed the proper framework for analyzing questions around the discharge. And I think part of this is corporations for the last 45 years, since the enactment of the bankruptcy code, have not been subject to dischargeability actions. And the framework I'm referencing is, for starters, and the Supreme Court has been clear about this for over 100 years, this circuit, as recently as 2019, has emphasized it, that exceptions to discharge are to be construed narrowly and in favor of the debtor. You could almost look at it from the perspective of tie goes to the debtor. If it is not clear that this is an exception to discharge, we need to err in favor of the debtor. And here it is not clear that corporations are now subject to all 19 of the discharge provisions in 523A.
So you accept the government's description of the Supreme Court's decision. You just say it's not clear here.
I'm saying, right, and what I'm saying, if it's not clear that a debtor is subject to this type of dischargeability action, then you need to err in favor of the debtor. It has to be crystal clear that, yes, you can bring this type of lawsuit against the debtor.
And so why is it wrong for us not to say debt is crystal clear? It's referring to a list of debts. It's not referring, right? That's to me sort of the underlying.
I think we go to then the second framework, which was pointed out in the brief of or amicus brief. When the bankruptcy code is amended, it is not done on a blank slate. You look at prior practice, and prior practice is not to be displaced unless it is clear in the congressional record or congressional intent. And when you look at the congressional record and the intent here with the SBRA, it is clear that Congress, in a bipartisan fashion and in record speed, wanted these small businesses to go through the Chapter 11 process more efficiently, cost effectively, and to get out of bankruptcy and succeed. If you go to the legislative history of the SBRA, 523A is referenced a single time, and that is just in the statute, the new 1192 subsection 2. And next to that, it says debts that were otherwise non-dischargeable are still non-dischargeable. So you look at that through the framework of we don't displace prior practice unless Congress tells us. Well, in the legislative history, Congress is basically telling us if it was otherwise non-dischargeable, meaning before the SBRA, if it was already non-dischargeable, it stays non-dischargeable. The prior practice before the SBRA was Chapter 11 debtors that are a corporate debtor do not face claims under 523A. They are discharged. They are eliminated. And so this would be a dramatic sea change, as Judge Horner, who actually wrote the opinion in Cantwell Cleary that was overturned by the Fourth Circuit, she likened it to hiding an elephant in a mouse hole. It's like if you're going to now, for 45 years, we've gone without subjecting corporations to non-dischargeability claims in Chapter 11 place. And mind you, Subchapter 5 is still part of Chapter 11. It is not its own new chapter. It's just a subchapter within Chapter 11. And we're not changing this prior practice here because somebody would have said something. There was,
It's too, Cleary was 2022. So it's too early to know whether this parade of horribles will ensue?
To some extent, here's an example. This is more anecdotal, but I'm finding non-dischargeability actions being fought in my corporate subchapter 5 cases now, where I'm a trustee. And so these were actions that if it was a traditional Chapter 11 case, they would never be filed. And I want to point out that corporations do not get claims of exemption, meaning they cannot shield assets from valid claims outside of bankruptcy. So even if these bankruptcy cases proceed, I think you had said before, Judge, getting torn down by 523A claims, it's like at some point when this bankruptcy is over, if these non-dischargeability claims are allowed to proceed, they will clean out the business. They will close it down. They will be able to swipe the assets. There will not be any type of exemption protection by these corporate debtors. And mind you, this only applies in a non-consensual plan. Right. In a sub 5 case, if the creditors all vote in favor, these claims are being discharged. And this is what makes it difficult as a subchapter 5 trustee is this is the only place in the code where Congress has said you as trustee have to facilitate a consensual plan of reorganization. It is going to be almost impossible to get creditors to consent to their own debt being discharged. And so that is a dramatic concern.
Counsel, was petition for cert filed in the Cleary case?
No, Your Honor, there was not. And I know I'm running over, but if I could address one of your questions from earlier, Judge Duncan. In the Campbell Cleary, Judge Niemeyer's decision talked about, the conflict with 1141D6. Right. What I can say to that is I don't think there is a conflict because when a discharge is entered or when a plan is confirmed non-consensually under 1191B, that is what triggers this discharge provision of 1192. If you go to the introduction of the SBRA 1181C, it actually makes clear that 1141D has no application in a non-consensual confirmed plan. So when a plan is confirmed under 1191B, you eliminate 1141D, but for this weird subset, 1141D1 actually applies to that district. So what I can say is, if we eventually get to the situation where it's non-consensual confirmation, 1141D6 actually does not apply under the language of 1181C.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Rebuttal argument?
Good afternoon again, Your Honors. Just a few quick points. Counsel for the appellee said words matter, but by the same token that words matter, a lack of words also matter. 1192 does not state a distinction between a corporation and an individual. The same way we give meaning to every word, we give meaning to what it is not said. Second, 1192, the plain language, counsel for the appellee said 523A is crystal clear that applies only to individuals, except, as was said, 1141D6. So we already have a frame of reference for 523 not applying only to individuals. Third point, in Ray JRB Consolidated, where the court said that it is not meant to apply to Chapter 11 debtors as a whole. Again, as counsel said for the appellee, that was pre-SBRA. So there's no way in Ray JRB Consolidated Court could have had in mind to not apply it to the SBRA because the SBRA was not even legislated at that point. Next point, as Your Honor, Judge Higginson, you said, there are already tools in the bankruptcy code to prevent frivolous claims. If a frivolous 523A claim was brought, there are already tools in the form of Rule 9011 to prevent frivolous claims, and there are penalties for bringing frivolous claims.
And the legal issue is stark, but the factual issue here is what? In a minute or even 30 seconds or less. Applied as to the facts of this case, what's happening?
The debtor signed an agreement where he received close to $200,000 in funds, said he had no intention of filing for bankruptcy. 15 days later, without making a single payment, he filed for bankruptcy for this company. And that is what they seek to discharge. And that is what the code is meant to prevent as well. There's a lot of talk about the SBRA meaning to give a fresh start to debtors, but that goes against the policy articulated by the Supreme Court that bankruptcy is meant to protect the honest but unfortunate debtor.
Do you have a response to his suggestion that this will make consensual Chapter 5s much more difficult?
I don't see how it would make a consensual plan. Again, this applies only to a non-consensual plan.
But they wouldn't consent if they felt they wouldn't be discharged, I guess. Isn't that the simple?
Well, I don't, again, that would go back to the point of them not wanting to do business beforehand. I think regardless of the types of claims, everyone has to weigh a claim. And there's a lot of factors that go into agreeing to a plan or not agreeing to a plan. And this is one of many factors.
It's been well argued both sides, so just quickly, do you have a comment on the Judge Bonifil treatise? Just because I like to look at scholarship. Are you familiar with that?
I did read through it, Your Honor. I don't have any specific comments, Your Honor.
Who won the moot court championship?
I don't recall, Your Honor. I was a judge on that,
you are.
that round. And
Good for you. No,
and I did grill the students extensively on this precise issue, and I did let them know as well that I had been working on that issue, and we had this appeal pending. And we also did put that in our petition for direct certification, just so the court was aware of what we thought was the importance of this issue.
Thanks to all counsel. We appreciate it. Thanks for the government for coming down. We have this case submitted, and